Assalamualaikum warahmatullahi wabarakatuh. In this video, we will be reviewing case Lim Teck Hong against Dr. Abdul Hamid, Abdul Rashid and another. This case review will be presented by me, Nur Amalin Irene binti Muhammad Razi with the metric number 2118712, along with Nurin Wafa binti Muhammad Khairi with the metric number 2116782, and Sharifah Kalsum Al-Qadri binti Said Zainal Abidin with the metric number 2112214.
There will be 6 parts in this presentation, which are the introduction, summary of facts, discussion of issues raised in the case that is relevant to the tort law, judgment, comment and analysis, and lastly the conclusion. So without wasting any time, let's proceed to the case review. Firstly, let's dive into the introduction. There are 3 areas of law that will be discussed in this case. The first one is breach of duty, the second one is negligence, and the third one is professional negligence. Breach of duty means failure to do something that you are legally responsible for, while negligence is a concept used to define whether a person's recklessness injured you. Meanwhile, when a professional fails to perform their responsibilities to the required standard, it is called professional negligence. In addition, the case of Lim Teck Hong against Dr. Abdul Hamid, Abdul Rashid and another is important because we could learn from this case that it is compulsory to act upon the problems we did, and we will never go wrong by working professionally without disregarding any party.
Before we start the presentation, let me introduce the characters that involved in this case. The first character is the first defendant, who is Jurusan Malaysia Consultants. The second defendant is Majlis Daerah Gombak, and the third defendant is Mighty Corporation Sedian Berhad. Next, the fourth defendant is Lim Teck Hong, and the fifth defendant is Leo Kim Seng. Meanwhile, the plaintiffs in this case are Dr. Abdul Hamid, Abdul Rashid and another.
Moving on to the summary of facts. The plaintiffs appointed the first defendant to construct a house on his property, lot number 3007, Mukim of Ulu Kelang, Gombak, Selangor, sometime in 1984. The fourth appellant is the owner of the first defendant's firm, which is a civil and structural engineers firm. The plaintiffs moved into their bungalow in 1985 once the work was done. However, in 1987, the third defendant, Mighty Corporation Sedian Berhad, started a new construction project next to the plaintiff's house. And about 1 year later, on the night of September 18, some of the plaintiff's bungalow parts fell.
This video clips is an example to illustrate how the bungalow collapsed.
Malo fali. Ode ona. Aa. Počeo ispadati onaj ćošak je. Ovo će let na jednom samo. Usjenić je. Čuje da lupi. To je to, počela je se rušiti. Počela se rušiti. Evo je. Evo je, evo je, evo je.
Plaintiffs sustained losses and damages as a result of their actions. Plaintiffs then filed suit against the first, second, third, fourth, and fifth defendant, but then the fourth defendant was the only one who filed an appeal to the court. At the High Court, 2 expert reports on the collapse were given as evidence. Dr. Ramli's initial report was filed by the plaintiffs, whereas Dr. To's second research was presented by the fourth appellant. The trial judge favoured Dr. Ramli's testimony since the date was closer to the incident than Dr. To's, and a statement was corroborated by the fourth appellant that he did not thoroughly investigate the soil where the bungalows were built. It vividly shows a professional negligence on his side. Then, the trial judge ordered the first and third defendant as well as the fourth appellant to pay the plaintiffs ringgit in damages, with the third defendant and fourth appellant being held responsible for 40% and 60% of the damages respectively. The third defendant was held to be 40% guilty of creating nuisance and negligence, which contributed to the bungalow's collapse. The third defendant was the only one who did not file an appeal against that verdict. Lastly, the judge did not award damages on pure economic loss as the respondents were affected by the loss of their bungalow, which fell a few years later after it was erected on that site. This was because the first defendant failed to do thorough testing on the site to determine if it was safe to construct a building as proposed by the first defendant on that site. Now, let's take a look on the issues. We have listed 2 issues from this case. The first issue is whether the first defendant held liable for not carrying out a thorough test of the soil before the bungalow on lot 3007 was built. And the second issue is whether the third defendant held liable for the losses and damages suffered by the plaintiffs after the construction works on a plot of land, lot 3008, adjoining the plaintiff's land, lot 3007, was made.
Next, moving on to the arguments for parties. The plaintiffs claim that they intended to build a double-story house on their property, which is lot number 3007 in Mukim of Ulu Kelang Gombak, Selangor, and that the bungalow would be their personal residence. When the plaintiff went to the first defendant's office, the fourth and fifth defendants alleged to be partners in the first defendant's company, according to the plaintiffs, but it was shown throughout the trial that the fifth defendant was just a clerk and a draftsman for the business, not a partner. Since the rear half of the bungalow collapsed and became uninhabitable, the plaintiffs suffered losses, damages, and expenditures. The plaintiffs then claimed that the damages to the bungalow and lot 3007 were caused by the defendants' collective or individual breaches of duty. The damages and loss sustained by the plaintiffs are detailed in the statement of claims schedules. The plaintiffs also claim that the third defendant allowed the infiltration or seepage of water into the ground and allowed it to overflow onto their land, causing soil saturation and the landslide that brought down the bungalow. The second defendants dispute that they owed the plaintiffs any legal responsibility, as stated in their re-amended statement of claim. He went on to say that he only has the jurisdiction under the Local Government Act to carry out works of such broad benefit to the residents of the local authority regions, as well as to do everything required or conducive to public safety, health, and convenience. The second defendant likewise asserted that they were not liable for any alleged loss, damage, or expenditure that the plaintiffs had incurred or experienced. Next, the third defendant then defends that they had built and finished the building on lot 3008 in compliance with the contract plans and specifications, as well as the orders of the architect and civil and structural engineers hired by the owner of the property. The third defendant also claimed that during and after the construction of the building on lot 3008, they took all reasonable measures and steps to avoid dangers and causing any damage to the neighboring lots, such as installing runoff drains, and that there were no unfilled trenches on lot 3008. Moving on to the defense from the first, fourth, and fifth defendant. The fourth and fifth defendants acknowledged being partners in the firm of the first defendant. During the trial, however, it was established that the fifth defendant was not a partner in the company but rather a clerk. They disputed that they had breached their duties and demanded that the plaintiffs prove their case. They further argued that by following standard engineering standards, they had fulfilled all of their legal and contractual obligations. The defendants claim that the collapse was caused by an uneducated owner's inability to maintain an originally stable slope, which was exacerbated by overburden and erosion. Then, the fourth defendant appealed this case. He argued that the learned judge erred in concluding that the fourth defendant did not do enough to assure the safety of the structure he constructed on lot 3007. He asserted in his statement that the bungalow was finished in 1985 and turned over to the plaintiffs on April 11, 1985. The bungalow didn't fall down until September 17 in 1988. He also claimed that the home on Lot 3008, which was higher than Lot 3007, was built later. It was also claimed that the bungalow fell 2 weeks after the third defendant started digging a hole. This trench gathered water, causing the wall to deteriorate and the cottage to fall.
Next, we move on with the judgment of the case. So, for the first and fourth defendant, since there was only one appeal before the court, which is by the fourth defendant, and no appeal by the first defendant, it is clear from the evidence that the fourth defendant was the sole proprietor and the alter ego of the first defendant, and the decision against the fourth defendant, which is the appellant, is a decision against the first defendant. It appears when this matter came up for hearing in the court below, the fourth defendant had been struck off from the register for committing an offense of running two engineering firms at two different places. The fourth defendant was apportioned 60% liability on his failure to exercise his skills and duty as an engineer and consultant in constructing the bungalow. The learned judge found that the fourth defendant was liable on the ground that the fourth defendant, as an engineer, should have taken more serious consideration of the ground and its vicinity in designing and devising plans that will make a house erected on Lot 3007 safe for habitation. Next, for the second defendant, the learned judge found that the claim by the plaintiff against the second defendant is based on negligence and breach of statutory duties. However, the learned trial judge found that the plaintiffs failed to establish the specific provision in the statute where the second defendant had breached. So, for the third defendant, the learned judge also found that the third defendant was also partly to be blamed when he constructed a trench near the boundary of Lot 3007. The purpose of the trench is to retain and collect water. The water collected saturated the ground mostly on Lot 3007. This was a contributory factor to the collapse. For that, the learned judge found that the third defendant to be 40% liable. The sum for the third defendant is 145,669 ringgit 20 sen. That is representing 40% liability. And for the fifth defendant, it was established during trial that the fifth defendant was only a clerk working with the first defendant and not a co-proprietor as alleged by the plaintiff. The learned trial judge then dismissed the plaintiff claims against the fifth defendant. So now, for the comment and analysis, to comment on the decision derived by the court held that the third defendant who did not appeal was found to have 40% liability as claimed by the plaintiff for causing damage to the plaintiff's property, which then the plaintiff succeeded his claim against the defendant. In the present case, the third defendant had artificially accumulated rainwater with the excavation, which was an alteration to the nature of the land. They had also disturbed with the rainwater by building transverse drains that ended 3/4 of the way down to the slope of Lot 3008. All of this had disrupted the natural flow of water, resulting in more concentrated and increased infiltration into the land, causing a destructive effect on Lot 3007. By doing so, the third defendant have breached their duty of care to the plaintiff in terms of negligence, caused nuisance to the plaintiff, and are liable in part under the Rylance and Fletcher rule. So by referring from the case of Rylance and Fletcher, the Clerk and Linsell on top 30 addition clearly explain the liability in respect of water. Liability in respect of water depends on whether the water is naturally on the land or whether it is artificially accumulated or interfered with in some way. The owner of the land on a lower level cannot complain of water naturally flowing or percolating to his land from a higher level. Nevertheless, the higher proprietor is liable if he deliberately drains his land onto his lower neighbor land, and this appears to be so if the water is caused to flow in a more concentrated form than it naturally would, as the result of artificial alteration in the levels and contour of the higher land. We are in the same page with the court that the third defendant is liable, as the plaintiff succeeded in proving his two allegations for unnecessarily allowing infiltration or seepage of water in the ground and allowing it to overflow onto the plaintiff land, causing saturation in the soil, resulting in a landslide which brought down the bungalow. Indeed, it was found that the third defendant was 40% liable for causing nuisance and negligence which contributed to the collapse of the bungalow. Next, for the second comments and analysis, to comment on the decision made by the learned judge, we are on the same page with the decision against the fourth defendant that are liable under professional negligence. If the court does not take further and deeper discussion reading two reports made by Dr. Ramli and Dr. To, the fourth defendant might run away from taking responsibility as a professional engineer. Besides, the fourth defendant submitted that the learned judge was in error in coming to the conclusion that the fourth defendant did not do enough to ensure the plaintiff's property was safe to live in. The fourth defendant also submitted that there was no finding on causation of the collapse. However, the court is presented by two reports from the firm KTA prepared by Dr. Ramli, tendered by the plaintiff, while the second report tendered by the fourth defendant. Both reports were clearly accepted by the court as evidence in respect of causation of the collapse. As a result, the court preferred the first report made by KTA with Dr. Ramli's testimony in court to explain it, while the second report made by Dr. To was done after almost 6 years after the collapse of the bungalow. If this case is being neglected, later on there might be an abundance of cases regarding the innocent people who are getting injustice and again neglected by professionals. However, in reality, the existence of the river that was neglected by the defendant should not be ignored, especially if there will be a residential area near it, as it has a potential threat to the landowner above. With a slope as steep as that found in Lot 3007, coupled with a river of swift-flowing water, the fourth defendant, as a qualified civil and structural engineer, should have taken serious and in-depth consideration of its presence when recommending, planning, and finally building a house above. Presumptions have no place in district, especially when the structure that will be built on it must be able to withstand and accommodate natural and existing forces. Thus, the court opinion believed that the fourth defendant, an engineer of such qualification and skill as the fourth defendant, should have taken these issues more seriously in order to design and devise plans that will have made the house erected there safe for habitation. Said to be truth, a casual attitude was adopted by the fourth defendant with little care and skill demonstrated. Such work by him is far from what would be expected of a professional in a similar field.
So, in conclusion, it is true the decision made by the court deciding the case towards the defendants in breaching their duty of care in taking great care of civil and structuring engineering in their professional field. As a professional with responsibilities, they must do their duties honestly and meticulously. This is because if something horrible happens as a result of their negligence, the victims may incur damages that could endanger their lives. Therefore, they must ensure that they do their work without making any errors that can risk the lives of their clients. Lastly, from this quote, we could learn that we should never run away from our problem, but instead solve them. In this case, it is clear that the fourth defendant tried to run away from his problem, but then got caught by the judge that he was negligent for not carrying out the important steps before building a house. In a nutshell, in every single thing that we do, we need to be extra careful to avoid problems in the future. But if a problem occurs, one must remember that they should never run from it. Well, that's all from us. Thank you to Dr. Sonny and the audience to watch this presentation.